Welcome to Conversations. I'm Suresh Kochatar. It's almost 2 weeks since the Supreme Court gave out an interim judgment in the Waqf Amendment Act case. Things have cooled down. Everybody has read, I assume, the 128-page judgment. What did the Supreme Court stay and what did they not stay? Because there are a lot of misinformation going around and by now a lot of things have been clarified. But for the sake of our viewers, I want to put this across to you. Ever since the Supreme Court delivered this interim order on the Waqf Amendment Act, a lot of people, including the legal eagles, have spoken about the judgment in their own way, depending on their political affiliation. The court said that it did not prima facie find several of the provisions under the challenge to be arbitrary, which means it's clear the government can go ahead. However, some provisions were stayed or clarified. In its 128-page judgment, a bench of Chief Justice of India, B.R. Gawai and Justice A.G. Masih expressed that prima facie it did not find several of the provisions under challenge to be arbitrary. And as I said before, some have been kind of stayed or clarified for a limited interim relief, citing practical considerations. So technically it is not a stay. Let's look at the highlights of the court's prima facie observations in the interim verdict. And now, point number 1. The provision of the Waqf creator must be a practicing Muslim. Now, the Supreme Court held that there should be a limited stay on this. The court held that Section 3, which makes it mandatory for the Waqf creators to show that they are practicing Muslims for at least 5 years, did not appear to be arbitrary. The possibility of any person not belonging to the Muslim community converting to Islam religion only in that order to take benefit of the protection of the Waqf Act so as to defeat creditors and evade the law under the cloak of plausible dedication cannot be ruled out, the court said. Now, why was this amendment brought in? It was seen that in many cases, Hindus who converted to Islam for the staying on the right side of the law by marrying more than once. So, somebody wants to marry a second time or a third time, under the Hindu law, it's a crime. So, the person converts into Islam. And when the disputes arise within the family, the person in a fit of anger decides to gift his property to the Waqf. And this purpose, he decides to convert to Islam. And that is exactly what is happening today. Third, and that is what I'm saying, the first one was regarding the wives, more than one. The second one was within the family, there was a fight. And the father gets angry, says, I'm not going to give the property to anyone. I'm going to gift it to Waqf. He goes, converts to Islam, and the next day he gives it away. Nothing can be done after that because once a Waqf, always a Waqf. That is why the government said there is a big conspiracy in this. The third was seen in many cases where the person who defaults on, say, a home loan or even a personal loan where he has put the property as a guarantor and decides to convert and donate that property to the Waqf. So he converts to Islam because he doesn't want to pay the home loan. And then he goes and donates the property to Waqf. Now the courts cannot do anything because the property is Waqf. The banks are left high and dry with no legal recourse. This is what they tried. The government tried to plug it. However, the court added that the rules must be framed before enforcing this provision. That is there in every case. We saw that in case of CIA also. The rules were framed after a long time. The government has to come back with rules and then this stay, this temporary stay also will go away. Therefore, this provision has been stayed only until such time that the rules are framed. Since no mechanism or procedure has been provided as of now for ascertaining whether the person has been practicing Islam for at least 5 years or not, such a provision cannot be given effect immediately, the court added. Next one, which is again very contentious, was Waqf by user. Now, there has been no stay on this. The court held that the central government's deletion of the Waqf by user from the earlier law is not arbitrary. In fact, the court also took note of Solicitor General Tushar Mehta's submission during the hearing that this deletion is prospective and not retrospective. That means the one property is Waqf by user before the Supreme Court's order will hold good, but again there are many legal challenges for that too. Therefore, the petitioner's concern that the existing Waqfs will be affected without basis, said the court. The court added there appeared to be a valid reason for deleting the Waqf by user as a means for creating Waqf property. If the legislature in 2025 finds that on account of the concept Waqf by user, huge government properties have been encroached upon, and to stop the said menace, it takes steps for the deletion of the said provision, the amendment prima facie cannot be said to be arbitrary. However, the court made it clear that no existing Waqf properties, including those created by the Waqf by user route, can be disturbed until the Waqf tribunal or whose order is appealed against in the High Court passes such an order on any dispute concerning the property. So, once there is a dispute saying somebody comes and says this is a government property and these people have usurped it, the Waqf board has taken it away, or this is a kind of property of the defense ministry or railway. So, the government can then immediately say, okay, we'll go to the tribunal, and if the tribunal gives an order which doesn't favor the government can again go to the High Court, and the High Court is the final arbiter in this issue. Next point, the point number 3 that we need to look at is the automatic derecognition of existing Waqf properties till the government official's report has been stayed. Now, what happened was when the amendment was sent to the JPC, or rather the Joint Parliamentary Committee or the Select Committee, the committee took a view that, look, the collector should not be the final arbiter in this. The collector cannot decide, because in Kerala, for example, the collector will favor the state government. In Rajasthan, the collector might favor the BJP government's view. So, there has to be a balance between it. So, the court said, the JPC also, the Select Committee said, somebody above the collector. So, maybe it be a principal secretary level person or somebody like that. But now, the Amendment Act provides for the derecognition of the existing Waqf until a government official inquires whether such property should be treated as a Waqf or not. Such state should be stripped away. And because it involves property encroachment, the court stayed this provision, saying an opinion that if government officers are given such power, it would violate the separation of powers in principle. The court held that the provision is prima facie not sustainable and in law and arbitrary. The question with regard to the determination of the said property's title being entrusted to a revenue officer would not be in tune with the principle of separation of powers as enshrined in the Constitution. The question of determination of the title of the property will have to, in the court's opinion, be resolved at a judicial or a quasi-judicial authority. So, it goes back to the tribunal and the High Court. So, the same thing that I said before. And the court added that such decision on the title of the properties must be left to the Waqf tribunals, and if an appeal is filed, then the High Courts will decide. Unless these judicial bodies decide on such questions, no Waqf can be derecognized, that it cannot be taken off the records or denotified or third-party rights created. In fact, it works both ways. Now, the existing Waqf board, for example, they were not even registered. So, many of them will lose their title, and I'll take it up that later. Now, let us come to the removal of Waqf status for ASI monuments. No stay here again. The petitioners argued that they were going to a masjid inside a ASI protected area. It might be a fort, it might be something like a Taj Mahal, or it might be something like the Golconda Fort. And they wanted, saying that that is the Waqf land, so we need to go there. No, the court said no. Nobody stopped you from going there and praying. In fact, there are many Hindu temples inside forts. Nobody has stopped it. The ASI maintains the entire property. People can go in and pray at a certain time of the week, certain time of the month, and certain time of the year. So, Section 3D of the Waqf Amendment Act lays down that the Waqfs created on properties that were notified as ancient monuments under the Ancient Monument Preservation Act of 1904 or the Ancient Monuments and Archaeological Sites and Remains Act of 1958 would be void. The courts refused to stay this provision, observing that there is no violation of the customary or religious rights, as I told you, to introducing such a restriction. In fact, the subsection 6 of the section 5 of the 1958 Act permits the citizens to continue with their customary religious practices even if such area is protected by the ASI. And in view of that matter, the court said, we do not find any case to be made out for stay of this provision. Now let's come to the fifth point, tribal lands. Many Waqf properties are now actually with tribal lands, and the petitioners said, no, even tribal lands can be Waqf. The court said, nothing doing, the amendment is right, tribal lands cannot be Waqf properties. So, court noted that the section 3E of the Amendment Act, which bars declaration of the tribal lands as Waqf, was introduced with the object of safeguarding the interests of one of the most marginalized and vulnerable sections of our country, the scheduled tribes. This cannot be said to have no nexus with the objects sought to be achieved. Such a provision cannot be therefore said to be prima facie arbitrary so as to stay the same, the court ruled. The sixth point, which is a minor one, which I feel actually the question is, should it have been there? I said, okay, fine, no problem. Non-Muslims on Waqf. In fact, the Waqf people and even the Muslim parties came back and said, oh, why not we have Muslims on temple committees? The problem is the temple committees don't have the powers which the Waqf board has. Otherwise, the temple committee can go and tomorrow say that this property which belongs to a Muslim or a Waqf is property belong to a temple. But that power doesn't come to a temple, say an authority or a Devasam board, as case may be, endowments board as we call it. Okay, let's take point number 6. On non-Muslims in the Waqf board, a clarification on the cap was issued. It was not stayed, by the way, because the petitioner's contention was that there cannot be non-Muslims on Waqf. The court said no, they can be, but they said they recorded the central government stand that not more than 4 non-Muslims would be paid a part of the central Waqf council. Is happening for the first time, and that not more than 3 members would be non-Muslims added to the state boards. So obviously for the first time, non-Muslims are going to be sitting on the Waqf board and Waqf council, which is a big thing. And the petitioners had objected to this, Kapil Sibal and others, tooth and nail, but the court said no. It said it is not going into whether this inclusion of non-Muslims in a Waqf property amounts to interfering in the religious matters in view of the central government's undertaking. However, therefore, to allay this apprehension that more non-Muslims may be made a part of these bodies, the Supreme Court issued an express clarification on this aspect. In order to avoid any ambiguity, we propose to issue a direction that the Central Waqf Council will have non-Muslim members not exceeding 4 and the main one and 3 in the state board, insofar as the board is concerned. 7th one was the ex officio member of the state boards need not be a Muslim. Well, no stay on this. The court, however, noted that since it's clarified the cap on non-Muslim members in the state boards, it will inevitably a Muslim majority body. There's no doubt on that. Therefore, it opined that there's no need to stay Section 23 of the Amendment Act, which provides for the appointment of an ex officio member from the state government as the CEO or the Chief Executive Officer of the state board, without any requirement that such official must be necessarily a Muslim. So it doesn't say that it has to be a Muslim, has to be the CEO. However, the court said that as a member, they should try and get a Muslim as far as possible to be appointed as a CEO. If it is not available or he or she is not available, then a non-Muslim can be made the CEO. Because end of the day, a Waqf board is only an administrative board. It is not a religious board. That is what we should understand, and that is what I think most of the people have not understood. When you look at a temple board, they are administering the temple as such. They're going into the daily affairs of the temple, they're managing the finances. Waqf board doesn't do that. It's administering the properties, it's taking care of it, recording it, kind of running it, getting the rents or whatever it is and all that stuff, but it is not religiously running it. So for example, it can be a Qabristan or it can be a Dargah. The Waqf board doesn't run it. There's a Mutawli who's there, whose job is to do that. It is not the job of the Waqf board. Anyway, I hope I clarified that point to you. Also, as soon as possible, an endeavor should be made to appoint a chief executive officer who belongs to the Muslim community, the court said, which is fine. They should search. If they don't get it, fine. Most important, the 8th point, registration of Waqf. No stay on this. The requirement for all Waqf to be registered under Section 36 of the Amendment Act has not been stayed, considering that such a registration requirement was there in the earlier laws. So, in the earlier laws also, there was a registration. The government didn't do anything new. It just clarified it. This is a big blow for the petitioner, especially many Muslim bodies who challenged this amendment in the Supreme Court. The initial authority for registration of the Waqf were the Mutawlis, who maintained the property, and they were least interested in registering it because they wanted to knock off the property and sell it or even gift it to the relatives. Later, this authority was vested with the state government. When the Mutawli started playing havoc, the state government took over, which is supposed to conduct a survey and then register the property. But believe it or not, only one state government has done the survey. As a result, lakhs of Waqf properties will now slip out of the hands of the Waqf board, because from 1923, This registration requirement was not there, but thousands and thousands and even lakhs of properties of Waqf boards were not registered because there were no documents. It was arbitrarily taken over and all under legal challenge. That is what happened. So, no stay there. That is the most important. Ninth, deletion of the provision that allowed non-Muslims to create Waqf. No stay. The Supreme Court refused to stay the deletion of section 104 from the earlier Waqf Act, which recognized and regulated the creation of Waqf by non-Muslim. The deletion of the provision which permitted a person not professing Islam to give or donate his property for the purpose of Waqf cannot be said to be arbitrary, inasmuch as even according to the petitioners, Waqf is specific to the Islamic religion. So, a non-Hindu cannot technically donate, which is why I said earlier, remember that they go and convert into a Islam religion and then they donate. And that was what the Supreme Court held was wrong. It cannot be done as far after the rules are framed, of course. It noted that if non-Muslim wants to donate a property, suppose they want to donate a property for Waqf, then they can always donate it first to a trust, which can then create a Waqf. Okay? They can donate to a trust, which can then create a Waqf. In fact, this case has a big bearing. This point has a big bearing in the Munambam case in Kerala, where more than 600 families were facing eviction because the Waqf board suddenly turned up 10 years ago and said this property belongs to the Waqf. Those people were staying for 3 generations there in this land, in this fishing village which is near Cochin. And of course, this judgment gives them a big relief. That's a separate case altogether. In fact, I'll take it up another day. Further, it appears that the above said amendment has been brought to make it consistent with the definition of Waqf under section 3 of the Amendment Waqf Act, which provided that the Waqf can be created only by a person showing or demonstrating that he is practicing Islam for the last 5 years. And this point, we took it up earlier. In fact, here again, the concept of practicing Muslim will have to be decided when the rules are framed. The 10th point, Limitation Act. Now, limitations apply to various things. When you go and file a case after 30 years, the court says, oh, why were you sleeping till now? Where were you? So, there were different points in time when the limitation law was applied. And here again, the government's amendment, there is no stay. We failed to understand, the Supreme Court held, as to how the Limitation Act of 1963, which is otherwise applicable to any other proceedings with regard to any other claim or interest pertaining to an immovable property, which is now being made application for the claim of interest or interest pertaining to the immovable properties comprised in a Waqf and can be said to be arbitrary. Court said while refusing to say the section 107 of the Amendment Act. The Waqf Amendment Act in many ways is a lot of legalized. In fact, the Limitation Act, which I said, sometimes it's 15 years, sometimes it's 12 years. After 12 years, you cannot file anything. The Supreme Court held limitations don't apply now. And that is what it is, because the limitations are removed. The government held, no, there has to be a limitation because every other part has a limitation. Why not this? There should be a time bound, kind of deadline for all this. Okay, now ever since the Supreme Court delivered this judgment in the Waqf Act, as I said before, a lot of people had said various opinions. But today I have tried to bring in 10 points because the Supreme Court itself held that it did not want to hear the entire thing. It is not going to stay the order of the Amendment Act. However, some provisions which need to be clarified or stayed or even given all green signal were taken up by the court. In fact, when the entire argument started, the court held, the 2-judge bench held that they told Kapil Sibal and others, don't come to us with the entire gamut of stuff, come with us to 5 points and argue only on those 5 points, and only senior counsels would argue. And that is how this issue was quickly wrapped up. Of course, this is an interim order. There will be a final order later, but this 2-judge bench won't be there then. A new judge bench will have to be created, possibly 3 or a 5-judge bench, and they will have to come up and give the final judgment. But knowing how the Indian judiciary works, that will never happen for a lifelong term. Thank you for watching. Jai Hind.